What if? What if the Norman conquest had never happened? Was it really a catastrophe that determined the whole future of English law as Maitland claimed? Or would this blend of centralised kingship and local feudal justice have occurred anyway? What if the Black Death had never occurred? Would the dawn of labour law, the class warfare, and the creation of the justice of the peace have occurred anyway? These are the questions of what if, which can be answered through a counterfactual legal history. A counterfactual legal history enables legal scholars to enter that what-if multiverse, and that's what I'm going to be looking at in this presentation. And this develops ideas and themes found in my new book, published recently by Routledge, Subversive Legal History, a manifesto for the future of legal education. And subversive legal history argues that rather than being archaic, legal history should be anarchic, because subversive legal history underscores that using history questions everything that students are socialised in concerning law. Comparison with the past underscores how the law and legal institutions are not fixed, but are constructed, that students are told a particular story about the law, and that every line drawn in the law and everything the law holds as sacred is arbitrary. It didn't used to be done that way. It doesn't have to be done that way now. It doesn't have to be done that way in the future. So subversive legal history underscores how the environment in which law students are socialised is a historical construct. It enables them to highlight, question, deconstruct and reconstruct the authored nature of the law, revealing that legal change on a larger scale than often realised is possible. So today I'm looking at counterfactual legal history as a method of this subversive approach. Does the controversial method of counterfactual history have the potential to unlock the subversive nature of legal history in a way that would underline the importance of a historical approach for all who study or research law? And the structure of today's talk is that it falls into four unequal sections. I'm going to talk a little bit about critical legal history, the background really of the subversive approach. I'm then going to introduce counterfactual history and the debate concerning that. I'm then going to distill 8 rules of counterfactual history from the literature, and then I'm going to talk about how that can be developed in law to develop a counterfactual legal history. So let's begin by looking at critical legal history. A lot of this will be familiar to you. Critical legal history is linked to the critical legal studies movement, and indeed CLS itself has been described as essentially a historical enterprise. It's epitomised in the US in the work of Horwitz and Robert Gordon, and in the UK by the work of David Sugarman. And looking in particular at the work of Gordon's work, which has now been consolidated into a edited collection, Taming the Past. Gordon's work is really the manifesto of what a critical legal history is. And he says that his work is about trying to tease out and make explicit a set of background assumptions, here called evolutionary functionalism, about the course of Western history that American legal scholars tended to take for granted, and to challenge those assumptions. So what is this evolutionary functionalism, which Gordon says is endemic within a legal discourse? Well, it basically does what it says on the tin. Evolutionary functionalism is the idea, brings together 2 main ideas. The first being evolution, the idea that all societies follow an objective path of progress in a way that is natural, so a Darwinian idea of evolution. coupled with a Durkheimian functionalist understanding of society as being socially differentiated into different institutions, which all serve a different functional purpose, be that law, be that education, be that the media, and the idea that society is based on that functionality and is based on consensus. And what Gordon notes in his writing is that this idea of evolutionary functionalism is prevalent and endemic in all legal and indeed all other discourse. And he said, while lawyers once played a moderately important role in actually writing histories, now legal writing is more likely just to assume that there's some objective, generally understood process of development that has been working away in the background, and leave the actual details of the process to vague implications. What he's saying there is the idea that evolutionary functionalism is taken for granted, those principles of progress, those principles of society being functional. And what Gordon also notes is that the main difference, as he puts it, between functionalists and critics is that while the functionalist examines what actually happens and explains how it all works, how it all fits within the pattern, critical legal historians take each event as situated not on a single development path, but on multiple trajectories of possibility. So critical legal historians look at the path that was chosen, not because that had to be chosen, but why it was chosen, why people pushing for alternatives were weaker. It looks at the losers in history as well as the winners. And as he puts it at the end of this quote, it raises the question of how can one identify the counterfactual trajectories, the roads not taken. Now, that counterfactualism is mentioned in Gordon's work, but isn't a major component of it, and indeed hasn't been a major component of much of the critical legal history that has developed since. And so this paper and the chapter in my new book looks in more detail at counterfactual history and explores how that could be used as part of its critical or subversive, as I prefer to call it, approach. Which brings us to the second part of the presentation. Now, counterfactual history is very popular in popular history, much more contentious in academic history, as we can see from the quotes on this slide. Carr saw it as being a mere parlour game. Hobsbawm said that it's not historical. If you're not concerned what actually happened, then you're not being a historian. Oakeshott saw it as a pure myth, an extravagance of the imagination. And Mergill said that it was imaginative literature. There's an idea that counterfactualism is science fiction, not proper academic history. But on the other hand, there are advocates who take the polar opposite approach. Clarke said that counterfactualism can rehabilitate history. It can free us from our vision of the world, which is overdetermined. Nambier said that the enduring achievement of historical study is always an intuitive understanding of how things do not happen, rather than how things do. And indeed, Max Weber has pointed out that counterfactualism is endemic in historical study, as he puts it, in every line of every historical work, indeed in any selection of archival and source materials for publication. There are, or more correctly must be, judgments of possibility. You're always asking what didn't happen as well as what did. There are three main reasons in the literature for criticism of counterfactual history. The lack of rigour being the first, whereas normal history there's evidence of why things went a particular way. For counterfactual history, where is the evidence? Second criticism, it's hampered by the problem of hindsight. Because you know where things went, that shapes your analysis of where things didn't go. either been overly bold or overly conservative. And indeed, the third criticism is that counterfactual history is often politically conservative. It's often very nostalgic, and it's usually based on this idea that individuals have a great power. It forgets the societal and cultural limitations that are on us, say its critics. And so that's why very often it comes from a right-wing perspective. But that third reason actually points to why counterfactual history is necessary. Because the reason why counterfactual history has been associated with the political right is due to the historical context in which much of that work has taken place. The main target of much of the work of counterfactual historians has been Marxism. And that's why counterfactual history is often seen as being a right-wing thing. But actually, as Andrew Roberts has pointed out, counterfactualism infuriates Whigs, Marxists, determinists, anyone who believes in some kind of preordained destiny or fate. Indeed, the thing that counterfactualism is actually opposed to, as Richard J. Evans pointed out, is determinism. The idea that events are or can be caused by forces external to human will. That's what counterfactualism is opposed to, and that's why it's of use, because it corrects the determinism found in orthodox historical accounts, say its advocates. Because, according to Neil Ferguson, one of the key advocates of counterfactualism, a counterfactual approach rejects the idea that the narrative thrust of history should be largely fixed as a story of improvement, of evolution towards perfection. So counterfactual history then provides a corrective to background assumptions that Gordon referred to as evolutionary functionalism. Which brings us to the 8 rules of counterfactual history. Counterfactual history has developed as a field of literature over the last century or so, and has developed as a more serious field of academic history. And in particular, over the last 40 years or so now, there's been a number of important edited collections, 4 of which are listed in front of you. And although there's also been monographs which have used counterfactual history, the value of these edited collections is that they include at least a chapter by the editor explaining the instructions that they've given to their contributors. And if you stare at these instructions, you can distill from them rules of counterfactual history. Now, that's not to say for a second that these editors all agree about the rules, far from it. And the longer version of this paper, which is available, looks, and is in the book, looks in detail at each of these 4 accounts. But I haven't got the time now to do that. So instead, I'm just going to look at what the 8 rules I've distilled from them are. And these are the 8 rules of counterfactual history. The first is that you apply the same standard and the same level of care as if you're doing factual history. The second is that the counterfactual variation which is chosen, and this is the key thing, what is the thing that you change? What is the what if question? That needs to be a turning point. It needs to be a key juncture. It needs to be a point of decision making or a moment of other crucial importance. It simply can't be about whether or not someone lived or died or whether something happened later. It needs to be an actual decision that changes the course of history. And it needs to be something which was considered at the time. The third rule is the counterfactual variation needs to be the only change made. The fourth rule is that it needs to be a plausible one, needs to be considered at the time. The fifth rule is the minimal rewrite rule. You change nothing else. The least tampering there is with the historical record, the better. The sixth reason is that you outline the reason for your choice of the counterfactual variation. The seventh point is that it needs to focus on the short term, or If you then say that it has other effects, you need to defend every single chain. And the 8th rule is that all counterfactual history should conclude with self-reflection as to the benefit of the thought experiment and how it is subversive, how it challenges conventional thinking. So, looking at the literature on counterfactual history shows us how it could work. Could it apply in relation to law? Yes, it could, I argue, because counterfactualism is endemic in law. As lawyers, as legal scholars, we are always asking counterfactual questions, as Amy Knight Burns points out in this extract. There are numerous counterfactual issues in law. Often we don't appreciate them as being counterfactual. Often we don't theorize about them in that sense, but they are nevertheless counterfactual. So legal history provides us with an ideal opportunity to be counterfactual historians. What if a case has been decided the other way? What if a statute or a particular statutory provision had not been passed? Would the change have happened anyway? This will shed light on whether cases, statutes, those particular cases, that particular statute are the best vehicles for reform. It will also cast light on what would and what was the role of people and factors outside the law in terms of shaping legal change. Counterfactual legal history can be used to question and to challenge the stories that are taken for granted and which have become foundational. They can question any assumption that the current shape of the law was inevitable or is natural. It provides a means of highlighting, questioning and superseding evolutionary functionalist assumptions. Counterfactual legal history would also shed light upon the experiences and stories that conventional accounts downplay or ignore, the role of activism, for instance, the role of minority groups. It would also examine what would have been the effect had opposition to development been successful, and could peek at a world in which reformers and minority groups were listened to. Such counterfactual analyses are likely to present a complicated, nuanced picture, both of what happened and what could have happened, because that's the key point. Counterfactual legal history sheds a light on the actual legal history, which, without looking at the counterfactual, you do not see. It exposes those neat lines of cause and effect which are drawn all the time with the benefit of hindsight in legal writing. So, in this presentation today, I've given you an idea of the benefits which could be gained through counterfactual legal history. As I say, the book Subversive Legal History, a Manifesto for the Future of Legal Education, looks in much more detail about why subversive legal history is needed, and also looks at how counterfactual legal history can be developed as part of that. What we looked at in this presentation is how counterfactual history has developed in history, why it's controversial, but why it's also needed. And I would argue that that check on determinism, which counterfactual history can provide, is definitely needed in relation to law, in relation to legal history, in relation to providing a check and a counterbalance to the stories we tell, and also the stories we forget. Thank you very much for listening. If you've got any further questions outside today's session, do feel free to email me or contact me on social media. Thank you very much.